47.1 For Dummies. There are so many misconceptions about this statute, and this case has been the worst thing that could have happened to it. Some think it's an unconquerable kryptonite that leaves the accused with no defenses, because that's the way it's been misrepresented. Others think it's a magical wand that can bring piles of money whether it's filed for the right reasons or not. Still others think it's unconstitutional as it stands today. The purpose behind it was meant to protect people who've been victims from being slapped down by expensive defamation lawsuits that are meant to discourage the actions taken against their harasser. Unlike criminal trials, in civil actions, if you cannot afford an attorney, you cannot get a public defender. To show how it's supposed to work, we're going to ask Barbie to help us out here. It's the first day at my new job. It's going to be so great. I'm here to help you design your project, Mr. Boss. Well, aren't you just the hottest little assistant? There's the hottie. Oh, is that a fuzzy? Let me help you. You seem a little tense. Here, let Big Daddy help you relax. Oh! He keeps touching me inappropriately and making sexist remarks. You are fired. I'm an attorney. We'll sue him. I'll sue you first. I can't afford 2 lawsuits. You win. This is what a lawsuit that's covered by 47.1 should look like. A victim takes out a lawsuit against a perpetrator. The perpetrator files a retaliatory lawsuit against the victim for defamation. The victim cannot afford to fight the defamation lawsuit. Unlike the harassment lawsuit, she probably can't get an attorney to take the case on contingency, which means no money up front, they get their cut in damages, which is often how you can file a harassment case. So when faced with this defamation case that they cannot defend themselves for, they end up cutting a deal to drop their case so that the defamation case gets dropped against them. That is what 47.1 is supposed to prevent. Looking at it from that standpoint, it has the possibility to be a noble statute, but we have to be realistic about the world we live in. Very few situations should be given absolute power. As soon as you do that, you've created a potential for abuse. I'm a big believer in the statute could be great if it required a full and complete investigation by a neutral agency first, before any lawsuits can be filed. That investigation would ensure that claims are valid. Then, applying a statute like 47.1? Absolutely. But going straight to a lawsuit and applying this statute, it just has too many problems. Is that situation the situation we have with the Blake and Wayfarer lawsuit? It is not. Let's look at the facts. Blake claims she filed a complaint in May of 2023, and then there are no more uncomfortable situations on set. Blake gets growing backlash for her appearance and later the marketing for the movie. In 2024, Blake and Ryan unfollow Justin. During the marketing, she encourages the rest of the cast to do the same. She stops allowing his name to be spoken or for him to be present for marketing. She banishes him to the basement at the premiere. Now, people really start talking. Also in August, Leslie and Stephanie start playing foolish games. Stephanie confiscates Abel's phone on August 21st, shares it with Leslie and Blake on the same day for her own petty revenge. She's angry with Jennifer Abel. She's angry with Wayfarer. But there's not really much she can do. So she does what she can to ensure that Blake will take this on for her. Blake falls into the trap and starts planning her war. She files Van Zandt in September to legitimize ownership of Wayfarer's texts. She contacts the New York Times. We don't know if it was before or after. She spends 3 months writing the biggest hit piece that the New York Times has put out in years. She closes Van Zandt on December 19th, files a CRD complaint on December 20th, and the New York Times story and accompanying video hit on December 21st. Lawsuits follow. Nothing about this is the typical filing of a harassment lawsuit, the kind of suit that 47.1 was created for. 2 things happen on December 31st. Justin files his lawsuit against who? The New York Times. And that's the proper way to file a Doe lawsuit, Does 1 through 100. He files this clearly in the state of California. How a Doe lawsuit works, if you know any of the names of the people you intend to sue, you put them. If there are unknown components, you list those as Does. As soon as you have those names, they're added. Now we know from the lawsuit filings that Stephanie Jones continued to access Jennifer Abel's cloud well into January 2025. We can assume she continues egging Blake on to fight this battle and informs her of what she's seeing. Because coincidentally, or not, on the very same day that Justin files his lawsuit, Blake files hers. She files hers in the Southern District of New York. On January 16th, a lawsuit is filed, but not by Justin himself. Remember what a true 47.1 looks like. This is Wayfarer Studios, Justin, Jamie, It Ends With Us, Melissa Nathan, and Jennifer Abel. Only 2 of these people have been accused of SH. That's important. Who are they suing? Is this just a retaliatory lawsuit against Blake? No. It's Blake, it's Ryan, it's Leslie, and Vision PR. Now, since Blake has already filed a lawsuit in the Southern District of New York, he has to post this related case statement. Courts don't like the messiness of related cases playing out in different courts. So what happens? It all gets brought together, one lawsuit, under the Southern District of New York. And for those of you asking, it would have been very difficult for them to have tried to keep it in California. So now with this combined case, the New York Times has also been consolidated into this. So it's not a retaliatory case brought against Blake. It's multiple people and entities versus multiple people and entities for the hit piece that New York Times put out. And you can see the difference. You remember what 47.1 was designed to put an end to is nothing like what we see here. These are all the people that Blake starts out suing. These are the causes of action. This is not a harassment case filed against a harasser. The countersuit starts off as said, and we substitute tag for Steve Sarowitz, 2 separate lawsuits, and we see the different defendants in that lawsuit, and we see the causes of action. This is not a standard 47.1 definition of a retaliatory lawsuit. This is about libel because of the article that was put in the New York Times. It also mentions all of the work issues, so that ultimately, this is what the lawsuit looks like. Multiple plaintiffs against multiple defendants with multiple causes of action going both ways. And even though Judge Lyman saw fit to dismiss these causes of action, most of them with prejudice, it does not and cannot eliminate the fact that there was proof of these things taking place. We also have the developing story of Van Zandt that we haven't even seen brought to court yet. These were real wrongs. It was not a frivolous lawsuit. And it is certainly not the standard type of case that 47.1 was created to conquer. The one like we see here. And like I said, using Blake's case to promote this statute for the first time, the people who wrote it should be begging her to take her name away from it instead of standing behind her. Because just like she's single-handedly destroying the Me Too movement, she's single-handedly destroying everything that this statute was written for.